This is part 2 as far as my lecture series on criminal procedure code is concerned. In the first part, we tried to understand the distinction between law which is required to be classified or which can be classified under substantive law and procedural law. Yes, we are dealing with procedural law, and as I have made it very clear during my last lecture that this is the lecture which we shall be devoting for the purpose of understanding the importance of the second schedule of the Criminal Procedure Code. If you take out your Bare Act and if you refer to the second schedule of the Criminal Procedure Code and start reading second schedule of the Criminal Procedure Code, you will come to know that you start reading right from form number 1 up to form number 56 of the Criminal Procedure Code is concerned. Now, naturally, what is the importance of this second schedule of the Criminal Procedure Code, for which you have to do some homework? You have to read section 476 of the Criminal Procedure Code, and to understand the importance of section 476 of the Criminal Procedure Code, you have to refer to article 227 of the Constitution of India. And then as you start understanding the importance of it, by merely reading various forms, it may not be possible for you to understand the importance of the second schedule of the Criminal Procedure Code. Hence, the time for me to start as usual with illustration. When we shall be dealing in detail right from section 61 up to section 90 of the Criminal Procedure Code, and the heading of the chapter is Processes to Compel Appearance of a Person in Court of Law. From the point of view of administration of justice, imparting justice, judge expects or wants few persons to remain present in a court of law, in the absence of which it may not be possible for judge to administer justice. Who are these persons? Accused persons. There cannot be a fair trial in the absence of accused person, barring few exceptions. The court may need presence of the witnesses, and these witnesses may be witnesses on behalf of the prosecution and witnesses on behalf of the defense. It's not only that we have two types of witnesses as it is understood in day-to-day life, but then if you read section 311 of the Criminal Procedure Code, you will come to know that court witness, namely a witness who is neither called by the prosecution nor by the defense, and when he is required to remain present from the point of view of deposing evidence in a court of law, court can call such a person and he becomes or he can be labeled as what is known as court witness. So these are the persons whose presence in a court of law is necessary for the purpose of administration of justice by the judge. Now, it may not be possible for each person to know as to the time, date and the place where he should remain present in a court of law. So, the court has to undergo various steps or method or measures which are laid down as far as this chapter is concerned. Which are those different ways in which it is possible for the court of law to compel appearance maybe of an accused person, maybe witness on behalf of the prosecution, maybe witness on behalf of the defense, or maybe a court witness? 1. Court can issue what is known as a summons asking a person to remain present in a court of law. If the summons doesn't serve the purpose, what do you mean by summons, with which we shall be dealing during course of our lecture, but if summons doesn't serve the purpose, court has got power to issue what is known as warrant. The warrant may be bailable warrant or non-bailable warrant. which is a direction given to the police officer to arrest a person and bring him before the court of law. But if it is not possible for the police officer to arrest a person and bring him before the court of law, court can resort to third measure. I call it a drastic measure, where there can be, court has got power to publish what is known as, there can be an order in writing, and this order in writing can be passed by the court of law. Court has got power to proclaim the person to remain present in a court of law. Publish proclamation. If proclamation doesn't serve the purpose, court can go to the extent of passing an order to attach his movable as well as immovable property. Now, in order to resort or understand this chapter, as I told you, if you refer to the bare act which you have and start reading right from section 61 up to section 90, you will come to know all the provisions regarding the same. For example, to know the provision regarding summons, you have to read right from section 61 up to section 69 of the Criminal Procedure Code. To know the provisions regarding warrant, you have to read right from section 70 up to section 81 of the Criminal Procedure Code. As far as proclamation is concerned, you have to read section 82, and then as far as the attachment of the property is concerned, you have to read right from section 83 onwards. Now, what is the importance as far as the second schedule of the Criminal Procedure Code is concerned when you correlate with this factor, with which we will continue our discussion as far as part 3 is concerned?